Hello, everyone, and welcome to the Supreme Decisions Legal Minute podcast. I'm your host, Supreme Decisions. Now, today, I'm going to do something just a little bit different because I gave you guys a bonus episode that actually came out on Christmas Day. So I hope you guys had an opportunity to listen to it and enjoy it. Well, today I'm going to do two things. First is I'm going to go ahead and get right into my commercial obligations. The first one being Urban Gyros Mediterranean Street Food. Mediterranean food with a urban twist. 1550 North Zaragoza Drive in El Paso, Texas, Suite 202. Go and enjoy it. Now, that burger spot number 3, South Lake Parkway in Jonesboro, Georgia. Your stomach will thank you. Great food, great service, great people. And again, your stomach will thank you. Now, the second part of the news is, starting in 2022, you've actually seen, I believe, one or maybe 2 episodes that have already been broadcast where not only do you have an opportunity to see me while, I guess, the video portion of the podcast being aired, but you also have an opportunity to hear me on all your major podcasting platforms such as Spotify, iHeartRadio, Pandora, iTunes, and many, many others. We are now in, I believe, 40 countries, and we are, I believe, as of last week, we're in Nigeria. So thank you guys for tuning in and listening, and I hope I can give you guys something of substance that you'll be able to take with you beyond today, and that will allow you to grow as we go forward in this journey. Well, today I'm going to talk about something which is pretty much I talked about as the cornerstone of all legal defenses, because we talk about discretion, we talk about the freedom of information, we also talk about things that are yours, but I'm going to go again in depth in the discovery process, which is one of, if not the first step that you will do, whether it's on your behalf by whatever attorney that you hire, public defender, or it's something that you do when you have a traffic citation or you've been issued some sort of warrant or things of that nature. Because under the federal rules of criminal procedure, a party must, without awaiting a discovery request, send out discovery. Now, the biggest things about that is most people have no idea what is actually supposed to be in discovery. And if you heard me, oftentimes I say it's not only what's there, but what's not. So today, one of the things I'm going to go into, and along with the depth of that, is what are you supposed to look for in discovery? When is it supposed to be done? And how are you supposed to get it? Because we also know that any right not exercised in writing is pretty much one that is given up. Anything that you do not request, you pretty much can't bring up or even use later, such as in an appeal. You can't even bring this up at trial unless you have some type of legal maneuvering during questioning that allows for it to be brought in. Notice I used the word allows for it, because the law doesn't care about how you feel about certain situations, but it does care about itself, because the law itself is very selfish. Doesn't care about your side, doesn't even care about the prosecutor's side or the accuser's side. It only cares about itself. Now, the easy part of this is one of the things a lot of people didn't even know they could request, but 90% of times, even in a basic discovery request, because this is also something I've never gone over that people are eligible for, is request recordings from inside the jail. Why? Because those recordings can be used against you in court. A lot of people have no idea why, I don't know, that they're being recorded when they're on the phones that are in the jails. You're also being recorded when you are going throughout the jail. You're also being recorded during visitation. Yet many people negate to even look for these things or even ask for these things. And what happens is you can actually have things that are brought up or even discount things that you may be charged of while in jail. Now, but again, that doesn't apply to 90% of situations. And it also doesn't apply to most people that are listening here. However, this is also something that can be applied. And I want to say maybe 3 weeks ago, I did a podcast regarding Giglio. I pronounced it wrong today, pronounced it wrong then. But it also deals with Brady. Now, when you're talking about that, I talked about the characters, meaning not the players, but the actors, but the actual person that someone is personifying or showing who they are, and how that is brought into court. Because even in those contexts, you can use for impeachment. Another thing that you can also request would be jail logs, and most importantly, because even when I talked about the Freedom of Information Act offering an opportunity to get police procedures, you can also get jail policy binders. These are things that can be requested through the Freedom of Information Act. I also looked at one where the GPS locations of a police officer can be used when you're talking about a proximity case, when you're talking about something that deals with in one manner, a police officer who does not file a report, you can actually pull up using specifics during a date, time, and location. Now, the reason why these are important is because now you can use that as a character inference. Because the simple fact that something is missing, because that will be the thing that's not in discovery, that you can also bring up, because there's even this thing called a scene report. You can now figure out, because just like Bivens v. I guess FBI, because it was 6 unknown officers. They were picked out because of the scene reports. And Bivens was able to sue them, even though they were unnamed in the actual lawsuit. And the context is going to be, when you're dealing with Brady, is to adequate acquaint participants with the actual file or thing that's being brought against you. Why? Because prosecutors have the opportunity to cherry pick cases that they want to prosecute. I'm going to go into issues that surround the Brady and the characteristics or the character that you can actually go into or attack during that process. I'm going to go into maybe 1 or 2 issues that may present themselves in the future when you're dealing with this, because I think that's the one of the things that a lot of people that I deal with don't kind of get. One of the things I have to do, or you'll hear any good representation of you, they'll tell you that they're managing expectations. Why? Because most people have no clue of what law is nor how it works. But they're willing to tell you, oh, I can do that, or you're not supposed to do that, or they can't do this. Yet they have no idea, because they've never done it. They've never sat down, they've never practiced. They never picked up anything, but they want to tell you how something works, which is the most amazing thing to me, because what they don't realize is they're looking to control you and manipulate you because of their lacks or their falling short of something. And again, if you figure it out, they then have to figure out why they have fallen short. And they have to have an explanation for their life. So a couple of cases that you're going to hear me go into is Brady v. Maryland, 373 U.S. 1963. Yes, a 1963 case. So this is for those people that like to hear should. The prosecutor, if they're looking for truth, should turn over evidence. Why? Because the defense attorney should vigorously defend you and only defend you against the evidence that has been presented against you. Yet there's very little time or oftenness of that happening. United States versus Giglio, 407 U.S. 150, 1972. Yet another old case, 1972. Then we go into U.S. v. Bagley, 473 U.S. 667. It's a 1985 case. Yes, it is still old. Kyles v. Whitney, 514 U.S. 419, 1995. And then we go to Strickler v. Green, 527 U.S. 263, and we're going to party like it's 1999. Now, understand the concept or the basics of disclosure and pretty much character, because you have the opportunity to face your accusers. You also have to go into the character of each witness against you. The government has a duty to disclose material exculpatory evidence. They also have the duty to disclose all evidence against you that they are going to use in court. Failure to do so violated due process. Now, when I talk about the appeal process, I talk about the FBI numbers of the prosecution actually convicting when going to trial or actually making a correct decision about an actual criminal is 1 out of 4. So they're wrong 3 out of 4 times. The failure violated due process, which is an automatic acquittal or appeal, where the evidence is material to either guilt, innocence of the accused, or the punishment. Understanding that is, while it's a simple, benign concept, it's one that's not exercised frequently or even properly. And even understanding this, there's no regard to good or bad faith of the prosecution. Why? Because the prosecution gets to cherry pick the things that they're doing. But the context of due process is a requirement that the prosecutors turn over favorable evidence to the accused and material to his guilt or punishment. This requirement includes evidence that may be used to impeach the prosecution's witness, including police officers. A lot of times I tell you, police officers cannot argue against themselves. We also know that they can't come in with hearsay, and they can only charge you or be a quote-unquote witness of things they actually seen themselves. If not, because they're coming in through an amicus brief, if not supported by evidence, it is deemed hearsay. The prosecution also has a duty to disclose if their witness has ever, including police officers, been untruthful or even accused of being untruthful in their statements that entered into a court hearing. Why? Because the prosecution is out for the truth. I'm going to go into cases later that even point out the fact that they have a duty to disclose evidence of testimony, willful or not, that was entered into a court hearing, or it is a due process violation, which is an automatic granting of an appeal. And one thing judges hate are appeals. Because if there's a lot of appeals beside the judge's name, that judge loses credibility. Now, Police officers and police agencies are, strictly for the purposes of Brady, considered to be part of the prosecution team. Why? Because the prosecution works hand in hand with the police on who they are going to prosecute. Now, I've also gone into Brady where they spoke about the simple fact, just because a prosecutor does not have things that's being requested under Brady, when you're using specifics, because the police still have it, the reliability or the liability still falls on the prosecution. Why? Because they're choosing to prosecute. And once they choose to prosecute, they have a timeline in which they must turn over discovery, which is 10 days. They used indictment. Because generally, for a felony, you're not even supposed to be arrested until you have been indicted. But again, that's in the world of supposed to. You're not supposed to be arrested until you've been indicted for a felony. Yet, more often than not, you see people arrested prior to a felony. You see people arrested prior to an arrest warrant. You see people arrested without an actual opportunity to have a complaint that allows for standing. Corpus delicti. Because again, these stupid words that people tell you that are dead, they keep showing up, yet nobody wants to talk about them because for whatever reason, they don't make any sense. And whenever I'm talking about them, I don't know what I'm talking about. I'm just talking. That's not real. Because under the Federal Rules of Civil Procedure, Rule 26, duty to disclose, general provisions governing disclosure. A is called required disclosure. Initial disclosure. Except as exempted by Rule 26 or otherwise stipulated, ordered by the court, a party must, without waiting discovery request, provide to the other parties the name and address and telephone number of each individual likely to have discoverable information, along with the suspect of that information, or the subjects, that the disclosing party must use to support its claim or defenses, that the disclosing party must use to support, So that must mean there's something else that's being supported. So there's something else that must be supported if they're using information to support a claim or defenses, unless it's solely used for impeachment. Now, that's solely used for impeachment. A lot of times that's where the loophole lies. Because, say, well, this police officer, if I turn this over, it's solely for impeachment that he lied. Absolutely. That piece of information. However, the simple fact that we're going to now offer him a second opportunity to lie would be the prosecution's choice, knowingly violating one's due process. Why? Because the witness is not known to be truthful. I'm going to say that again. The witness is not known to be truthful. And one of the easiest questions to ask when cross-examining a police officer is, in your history, does your department policy require that you use stock language when filling out your police reports? Now, you already know the answer to that. The answer is yes. Any answer that is to the contrary is a lie. It is perjury. Second question is, does stock language allow for you to elaborate or even offer specifics of any given situation? That answer is going to be no. You know that answer. Third question would be, in using stock language, has your police reports ever been brought into question as being untruthful? Now, keep in mind, the reason you ask this question is because that police report is signed as an affidavit. It is signed under the penalty of perjury. If that question is not answered honestly, you now have not only perjury, but you have grounds for a full and complete dismissal and a civil rights violation that can be punished in federal court. Why? Because a police officer loses immunity through willful acts, which a deliberate lie would be, or through ignorance, which would be if he tells a lie not knowing it's a lie. Either way, he's incompetent and unable to fulfill the duties of his job as law enforcement by not knowing the law. I'm going to say that. Incompetent and unable to fulfill his duties as a law enforcement officer because he does not, or she does not, know law. Easy part about that is the case I did that involved the town of Prince in Philadelphia. Jordan v. Prince. And Prince found out that there's no obligation to hire a police officer with an IQ above 104. We also know that most police officers don't have an IQ higher than 104. We also know that it's easier to train someone that will not question the acts if they are not deemed intelligent enough to ask those questions. Which is why I use the term several times as attack dogs. They're trained attack dogs. When you have an opportunity and you have an oath to do no harm. Remember I did the I believe it was a video, 3 Laws Perfect. Why? Because it was a spinoff of iRobot. The funniest part about this, I also played Training Day with Denzel Washington. Police officer's oath, similar to the Hippocratic Oath, which both are non-existent, is do no harm. Why? Because they are servants to the public. Because they are servants to the public. Because the police officers are servants to the public. Do no harm. They are given. Not my words. These are the words that came directly from the FBI and those of you that listened and watched the live show, the Philadelphia Police Department. They are given at any given time, not 1, not 2, but 7 non-lethal instruments at all times to subdue other human beings. Uh-oh, maybe y'all didn't catch that. I said human beings. Because they're innocent until they are proven guilty. They are innocent until proven guilty. These human beings are innocent until they are proven guilty. Which is why when you're doing discovery, the prosecutor is supposed to turn over evidence of this said guilt. Which is why we have Brady. Which is why I talked about the Tommy Sotomayor questions, his stepping stone, his 5 steps, parts of the ladder, which is why I talked about this. Yet, they criticize me for it. I'm talked about for it. I'm going to expose him as if it changes the weight of the words or the actual situations. They're given 7 non-lethal weapons, yet, because I can actually just go to Houston last night, within hours, 2 separate situations. Police officers, and what's funny is, I often tell you, you can't argue with yourself. I actually watched the interview where the police chief spoke about the first shooting. They were called out to shots fired. That's what it said. He said they were called out to shots fired. When they came to the scene, they told the suspect, they commanded the suspect to drop his weapon. Words have power. He stated, when the police officers got on the scene, they commanded the suspect to drop his weapon. He refused to drop his weapon. Then, in the exact same breath, the police chief said, he then went for his weapon. Wait a minute. How can I drop something if it's not in my hand? That's 1. And 2, if it's tucked away in a waistband, in a gun holster, in a carrier, somewhere other than my hand, wouldn't I have to remove it? Or, as he put it, go for it to pull it out and drop it? No body cam footage, but again, we'll get into that. Second incident. They said they caught up with a young lady. She took them on a small chase. I don't know what a small chase is. She then confronted the officer. Wait a minute. So she was running from the officer, then all of a sudden she runs to the officer? Because she confronted the officer, not the officer who was chasing, confronting her. But then the officer shot her multiple times. Now, I'm not a weight expert, but the officer that shot her was more than 200 pounds. The young lady herself was maybe 110 pounds. She's very thin. So we're talking about a weight difference of over 100 pounds. We're talking about someone who had an opportunity to use a taser, to use a beanbag gun, to use a baton. You know, the things that they used, on Kenneth Chamberlain Sr., the guy they was making sure was okay. But again, no body camera footage, because pictures are worth 1,000 words, but a video lets you continue to talk forever. Because remember, there was no video of the police officers murdering Kenneth Chamberlain Sr. But the audio contradicted everything that these police officers wrote and swore to, using stock language. that had already been reprimanded multiple times for excessive force and lying on police reports and using racial epithets to refer to the people they serve. Yet this was not disclosed, which allowed, although Kenneth Chamberlain Sr. had passed on, it also was the grounds for actually opening up the federal lawsuit a second time. Why? Because this evidence was presented. It was even ignored. But most people come focused on the fight, the battle. Very few become preoccupied with the war. But had they not done a proper discovery, had not done a proper request for this information, we wouldn't be continuing to have this conversation. But even in these contexts, why was it necessary to the one lethal weapon being the first option versus the 7 non-lethal weapons being a secondary option at best? Because when we're looking at this, Brady rule includes evidence that can be used to impeach a witness. When the reliability of a given witness may be determinative of guilt or innocence, non-disclosure of evidence affecting credibility falls within the rule regardless of whether withheld in good faith. Which means when you're asking these questions of this police officer, when you're asking for the report, when you're asking for the arrest application, the arrest warrant application, the search warrant application, because we know from Supreme Court cases, police officers, Jordan v. Prince, they're not intelligent. I also went into a case where it stated that a non-biased judge or a non-biased magistrate must sign off, if not given consent, because police officers do not have the wherewithal to determine what probable cause is. Must. So either a judge or they must get consent, because police officers are not smart enough to determine what probable cause is. I'm going to say that one more time because, again, whether you like it or don't like it, it's not my words. I am repeating law, a Supreme Court case. This is a holding. This is a precedent. Even in disclosure, one that I always talk about the things that you don't see. One of the great parts about it is understanding that someone is arrested, understanding charges. When you're looking for the booking information and you look at the arrest warrant filings, look at the time. Look at timestamps. Because men lie, women lie, timestamp doesn't. Timestamp can't even be altered. Even when you're looking through documents, one of the things that they always mess up on is that they number pages. You'll see 1, 5, 7. Like, hold on, what happened to 2, 3, and 4, and 6? What happened to these pages? You can now be specific in asking for those pages. Even if they're blank, the fact that they did not disclose them originally can now be used to paint a picture. Because you can simply ask, did we have to ask for, you know what, I'm actually throw something else out at you. One of the things I actually love the fact is law. It's understanding the context, understanding, painting that picture. Most people didn't even know that you could subpoena a witness. Most people did not know that you can actually subpoena the DA or a prosecutor if there is some relevant part of your case that the prosecutor participated in. Now, the example I'm going to use is I actually subpoenaed John Melvin. He's the prosecutor that was in my case. John Melvin didn't do a lot of the arguing. I actually wasn't planning on calling him at all. Yet, the reason I was able to subpoena him as a witness was the simple fact that John Melvin went into the news to speak about my particular case, and he used words that actually spoke to the guilt or innocence of myself and others. But he specifically spoke about my case, which allowed and made him free game. Could I have used that? Absolutely. But he was doing a good enough job to where I didn't have to. Because the whole part about it was the painting the picture. Was that the ace up the sleeve? Absolutely. Did I need it? I'm glad I didn't. But here's the problem. Let's say that would have been the turning point, and I didn't call him, or I didn't subpoena him as a witness. Did I not do something prior to? Did I not have grounds to properly do so? These are things that I'd have been sitting in my jail cell wondering, because again, there were things that I could have asked for in discovery because of his conversation on the news about this particular case. These are things that you can use to weaponize your defense. That is coming in 2022. That is why you're getting these podcasts on a timely basis every Monday, 5 a.m. on each one of your major podcasting platforms, starting out with iHeartRadio and Spotify. Yes, those are shameless plugs, because at the end of the day, it's about keeping growing and keeping going. We're going to keep moving towards what it is that we need to actually begin to make sure our rights are not only respected, but expected. We're not going to only make sure they're respected, but they're going to be expected. Because I want you to understand that 5, just turning that 5 to 10. If you have 10% starting to fight back, that will be 200,000 out of 2 million every month that's fighting back. That becomes a problem. That becomes an opening. Why? Because now you have to pay attention to, oh shit, we have more cases being filed because of. So the one area that we all agree that needs to happen is training, retraining our police officers, and getting not only those that are going out, but it also goes around the context of we're going to get not only better, but smarter police officers that are going out and actually fighting crimes, not creating them. That know law, not just enforcing statutes and codes that apply more so to businesses versus those that are living human beings and individuals. Now, I want you to understand something, because these words have power. There is no legal distinction between exculpatory evidence and impeachment evidence for purposes of the Brady Rule. So when you're asking for this disclosure, understanding that the state's attorney general is the one that makes the determination on what does not get turned over, it becomes something else. Making that determination, only the state's attorney general makes that determination on what does not get turned over. Favorable evidence is material if there's a reasonable probability that would have been different if the defense had known, to which now the harmless error standard does not apply on issues if whether material evidence is available. Harmless error occurs. Got your pen and paper out? I want to make sure you're ready. Harmless error occurs when there's an intentional act done. You know, when you actually don't send over, requesting discovery. When you actually send over a complete discovery that reads a little something like this. Hit it. Any and all audio associated with the above charges, which include any and all communications made to and from all officers on the scene, which would include the call to the officer to report to the scene, the emergency call made to request police services, calls made and received by the officer during the first contact with the accused, any and all video associated with the above charges, including the dash cam video of the officer making the initial stop, and any and all body camera footage in its unaltered state. Why do I say that? I'm gonna give you a great one. You ready? There's a couple of states, I'm not gonna name them, that have a requirement of body camera footage to be turned in immediately after any shift. Now, let's say a police officer works a 14-hour shift, so, God forbid, because they're so exhausted that they can't figure out which house to go into and kill the residents. But let's skip that. And it's okay to subject 14-year-old children to 17 hours of interrogation without food and lying to them constantly. But we're going to go just with the police officers in their 14-hour shift, and they don't turn it over, or they turn it over and no one sees it for 2 months. And then of a 30-minute encounter, we get to see 18 seconds of edited footage. 18 seconds of edited footage. Now, I'm going to give you an example. There was a young man who fell asleep in the driveway of Wendy's. Yes. You guys remember that? During the shutdown, whenever the police lost their mind in Atlanta. There was a young man who fell asleep in the driveway of Wendy's. Yes, he was drunk. He admitted he had been drinking. He then pulled into a parking spot. Police officers are there. They're talking with him for over 30 minutes. Another officer pulls up. Now, if you let Officer Kelvin Dingle tell it, police are professionals who are trained to de-escalate the situations because they're professionals. Yet this third officer shows up on the scene and he immediately escalates this conversation. He becomes aggressive. Haven't figured out why. Yet he attempts to tase the young man multiple times. The young man takes a taser. He then shoots the man in the back twice. Now, he used the word, he was under imminent threat of a taser. So that meant that the taser was being used towards him, right? Because the taser is a lethal weapon. He just used it twice to no avail. So he's telling the world that this man, this common man, is more manly than he is. He's superhuman. It's easy to believe because he's a minority. And all minorities are scary people and they're superhuman. At least that's what the programming tells us. But I'm gonna actually stop right there because he shoots this man in the back twice. Pow, pow, in the back. Use the words imminent. Imminent means immediate, coming towards. So there is no imminent threat if someone is running away from you. There's even this case called Tennessee v. Cardinal that does not allow police officers to shoot someone in the back that's escaping. Because if a taser is non-lethal and a taser with no ammunition or charges are available, you cannot then use said taser as a threat to anyone. You cannot use said taser with no charges as a threat to anyone. But now I'm going to back up a little bit, because a couple months prior to, that same police officer was reprimanded for discharging his weapon without just cause. Got slapped on the wrist. 1 week after being brought back after shooting this man in the back, he was then involved in yet another, a third officer-involved shooting. Do you see where I'm going with this? This police officer is horrible as a witness. His character is shit. I want you to understand that. Anyone that is dealing with Officer Rolfe in Atlanta, Fulton County, if he is on the witness list, his character is trash. Why? Because he's known to not make rational decisions. He's known not to be a reliable witness, but this is also something that is known by the prosecutor prior to choosing to prosecute your case, which also must be disclosed during Brady, which also allots them not having the ability to use harmless error when they're putting him on the witness list and allowing him to testify. Because it's a blatant violation of due process, because this man is not an honest person. I'm gonna even give you one. If you ever want me to testify, yeah, I'm a horrible witness. I'm not good. I'm horrible. I didn't even testify in my own case. Why? Because I am a horrible witness. My character does not allow for me to be on the stand saying anything in a positive light. I want you to understand that. Regardless of however you want to paint me, oh, I appreciate you. Yes. Hashtag the truth still hurts. At the end of the day, I am not a very good witness for anybody about anything. Now, if you want me to speak directly to law, absolutely. Anything outside of that, I am a horrible witness. Probably not even good to use me as a expert witness, because again, my past can be brought in, because you can assassinate my character. You can't change the law, but you can paint a picture. I want you to understand that. These are things that most people don't like to talk about, don't even like to hear. But at the end of the day, I don't care. I actually can live with it. I've been living with it for more than 20 years. I'm okay with the fact that know thyself. That is one thing I teach my children. That is the first thing I teach people that come around me. Know thyself. Because once you know thyself, you can then move forward in doing whatever it is that you understand. Because whenever someone comes against you with your trash, you understand what a garbage can is. You can put it right back on in there. Because I'm good with it. If you need something else to live with, that's on you. I have nothing to do with that. Because even with me, one of the things I constantly say, I've even said to other people, now a lot of times I want you to hear an issue that I have. Because if I don't allow you to hear it, there's nothing you can do to fix it. But if I air out my grievances to you, that doesn't mean that it's a you issue. It's still my issue. I want you to understand. Just like my feelings. I don't give a shit about your feelings. No one cares about your side. But at the same time, it's not for everyone to care about my feelings or my side. It's not my business for me to care about your feelings or your side. You are the one that has to live with it. Because again, if you live in should, then okay. I don't live in should. In reality, no one cares. But understanding this is important. Not directly to you, but for you and with you. Because knowing is half the battle, and it allows you to grow. And that's what this is for. Growth. Now, knowledge input, goodness, I can't speak today. Knowledge inputted to the prosecution includes knowledge that the police may have. Prosecutor has the duty to learn of any favorable evidence known to others acting on behalf of the government. This includes the police. They have a duty. They have a duty. Now, I'm gonna stop for a hot second because I want you to understand something, because I've used this word before and, jackass got upset with me. It's cool. I get it. Because it's easier to become upset than it is to actually look it up. Prosecutors have a duty to the public because they're speaking on behalf of the public, which is why they're liable. Whether they have something, when you ask for it direct, they have to give you what you're asking for because they are servants and you are innocent until proven guilty. If they don't give you what you're asking for, is a violation of due. It's funny how people will tell me that they don't have to do nothing. And it's funny, you think they have procedures. Yet, not only when you ask for it, they have liability if they don't give you what you're asking for. And they have time limits on that placed upon them, not by them. Isn't that amazing? And if they don't do what they're asked, because even if you look up motion actually means demand. It doesn't mean request. It literally means demand. You're demanding discovery. Because I often tell people, whenever I speak to my employees, I don't ask them anything. I give them instructions. Through instructions, that's my demand. I'm not asking for discovery. I'm giving you instructions. So understand those words. Words have power. Just because you change the meaning of it or how you want to spell it, it does not change what the word itself means. And what happens when someone tells you, oh, Latin is a dead language? Let them go to court and see how dead it is. See how they finna get off. Or holler a couple of bruhs and see what effect that has. Because again, now they're no longer speaking the language of the court. Those words are dead words. Ebonics is a dead communication. Because those that are speaking it are dead between the ears. I dumbed down for my audience and doubled my dollars. Jay-Z told you this. You criticizing for it, yet you holler. Understanding. No child left behind leaves every child behind. There are so many children that are being pushed through the system. When Jaden Smith spoke about the school to prison pipeline, dumbed down for my audience. Because if I'm allowing ebonics, if I'm taking away grades and I'm taking away knowledge, I'm taking away opportunities for defense. If you're sending your child to school with no expectations, you are murdering your own child. Because you're sending them out into a place where they have no opportunity for a defense because you are allowing them to go out into war defenseless. You're sending them out with no weapons at all. You can give them armor simply by giving them instructions, allowing them to walk in a light. It is not our darkness that we most fear. It is our light. And a lot of times when we think about that, when we're sending them out, and we're sending them out with expectation, that responsibility still falls back on us. And what our society allows now is for our parents not to have, you know what? Allow our parents not to be parents and don't want them to have responsibility because you allow them to take it from you. Dumb down for the audience and double their dollars. They dumb down their audience and double their dollars. They dumb down their audience and double their dollars. Every time you text bruh, every time you text finna, gotcha, who dat? Unless it's football on the Saints, you know, whatever you do down there in Louisiana, that's y'all thing. But understanding when you're doing a regular communication, when you're speaking with ebonics, when you lack the ability to spell probably, you are okaying the dumbing down of their audience. You're funding your own, you know what? I'm gonna get back on this real quick, but I have to talk about something because it was a young man, and he and we were talking, and the conversation came back to reparations. Oh, they owe us reparation. They owe us reparation. They owe us reparation. And I asked him why. Why? Why is tell me, give me your idea of why someone owes you something. He said, because we were slaves. And I gave him the asshole Kanye remark. When were you a slave? I said, because last time I checked, you and I are the same age. You and I went to the same school. You and I were in very similar programs. One of us lives off the state, the other one doesn't. One of us has created multiple businesses, the other one has only worked at fast food places. And he looked at me, he goes, well, when you did it, you were the exception. I said, okay. I said, I'll call that fair. Let's say it's fair. We lived in the same neighborhood, went to the same school, pretty much ate the same food. We were in the same thing. Not the same, similar. I then rattled off 20 other people that was not only in our graduating class, but that were in our same area that went on to be successful. And then I asked him, I said, well, what do you do daily other than drink? What opportunities are you tracing? What applications are you filling out? Who's around you? And I'm gonna lump something in because I'm gonna bring you back to that. I spoke with an old man. He and his wife have been married since they were 18. They were in their mid-70s. So you do the math. I asked him how they make that work. The man said it's easy. He said, understand who makes the decisions? And he said, smile and say, yes, ma'am, a lot. I cracked up laughing because I understood where he was coming from with that. And I looked over at her. She said, well, mine was easy. She said, because I understood, because my father was similar. My uncles were similar. My friends' husbands were similar. I said, okay, what was that? She said, a man does two things. Where a man spends his money and where a man spends his time is what that man loves. Now, I'm going to fast forward. I asked him where he spent his time at. Who was he spending his time with? The context of that were with people that were just as dead as he was between the ears. Same people that were drinking constantly. Same people that saw the world as a horrible place to be. Same people that were not looking for prosperity. So they all found what they were looking for. I asked him where he spent his money. He spent his money on getting lost. And what I mean by that, he spent his money on drugs. He spent his money on alcohol. Both of those are depressants. Both of those are things that take away from what it is that you're looking for. If you're spending more on those areas than you are on building something, that's where you're going to live at. People will spend more money on their deprivation than they will on their salvation. And then sit and expect reparations. Why, again, you're expecting someone to take care of you because you have chosen not to take care of yourself. When I spoke about the man in the arena, I spoke about those that are taking care of themselves. They're not allowing someone to speak for them. And those that do allow someone else to speak, they're telling them what to say. They're taking control of their life. They're speaking up for what it is they want. And there's an understanding that they're taking responsibility not only for their outcomes, they're taking responsibility for their shortcomings. Because even if they're blessed and they're understanding the battle, they're looking forward to the end of the war, which they will prosper. Even if they're losing the battle, they're looking forward to the war where they're winning and will prosper. I did a video that talked about the preliminary hearing. Preliminary hearing, because again, when you're cherry picking cases, I talked about the quotas because people are using the legal system as weapons and revenue generation. They're business oriented. I looked at that and I said, you're going to lose 99% of those. Why? Because the prosecutor is cherry picking your case. So that tells the judge that apparently this mug sees something that I don't, because they're playing a card game. This is chess, not checkers. You generally can't see the entire board with one move. I'm going to say that one more time. You generally can't see the entire board with one move. But understanding where that goes from. When you're doing this. Understanding the first step in any of this is knowing what to ask for and how to ask for it. Understanding you know what? I often sit down here and I go through these, I guess, examples, because the reason why I speak on a lot of this is because I've been through damn near everything that I've given you examples of. I used at one point or another in my life or in someone else's life, or against this person or against that person, because I don't play law. I live this. I continue to look to improve. I look to sharpen my sword, so to speak. And in doing so, I'm looking to not only improve me, I'm looking to improve you. I'm also tired. And I can't sit on the sideline and continue to look at, one bad thing happen after the next and then just being okay with that. So this is my form of fighting back against that. This is my hello. The supreme decisions that you've had before was a guy that was looking for something. He understood there were going to be battles. He was ready for that. That supreme decision I had to grow from him. That's why a lot of times when you're hearing my podcast, I open up with some form of direction, which is done through either a one-liner or a poem or a parable or some sort of soliloquy, to where, in fact, I can offer you direction, because the vision has not changed, but it has expounded onto something else. So therefore, the supreme decision that started this cannot be the supreme decision that continues this. I have to grow along with this. The channel has to grow along with this. The information has to grow along with this. With that being said, although I'm just touching on, character, and I'm touching on Brady, I want you to understand something. The stories I give you have real foundation. Each one of these are done sometimes on the fly, but it's all done with purpose. Because I want you to see what it is I'm seeing. Are you going to see it the exact same way? Hell no, I get it. But it's cool. That's the whole thing, because everything I'm giving you is for you to take it and make it yours. That's why I give you the Supreme Court cases when I'm talking about a particular subject, because now not only do I have to give you this subject, you can go and check it out for yourself, and you can expound on what it is that I'm talking about. Because every time I speak, every time you learn, we can have a deeper conversation. Because I'm not just talking about surface stuff anymore. Will you still get some surface? Because, yeah, absolutely. Because there are certain things that should not be on YouTube that I'll give you in the masterclass. There are certain things that shouldn't be on a podcast, but I will give you in a masterclass or on some other personal level. But at the end of the day, there are things that you have to exercise, you have to take responsibility for, you have to actually move forward with. Because even when you're talking about impeachment of a witness, most people don't know that while you can't get medical records, you can also understand inebriation, where they medicated when the conversation was had. Were they intoxicated when the conversation was had? Have they ever filed a false report? Because we have these people that we forget about the totality of circumstances. Because I did the video, he said, she said. But when you have a police officer acting without totality of circumstances, subjecting someone to a felonious condition prior to. When you have police officers showing up on a scene and shooting a security guard that was holding a would-be gunman. Because, again, without doing totality of circumstances, understanding that even from tips, the caller can't just say, suspicious, he looks suspicious. They have to articulate an illegal activity. Because I literally just had a conversation with a young lady just a few seconds ago, prior to even starting this podcast, in which she asked, she was like, well, why did you pull me over? And she was kind of loud. And I told her, I said, why don't you ask him? I said, because he's probably going to use, you look suspicious, what activity that you are participating in that he believes is illegal. That's a simple question. Because regardless of the call, he can no longer use suspicious activity. He has to go along with illegal, because that's what has to be articulated, even if he's called to the scene. What activity do you believe I was suspected of doing or participating in that is deemed illegal? And guess what? I don't know isn't sufficient for a warrant. I don't know isn't sufficient to override Florida v. Royer. I am not a police officer. I do not have to participate. And guess what? I am going to remain silent. You have 19 minutes. It's not rocket science. Yet, when you have someone with a low IQ, they are not trained in scientific issues except when they are creating a crime. Because you hear them all the time on videos where they're manufacturing crimes, where they're manufacturing things that they want you to believe is evidence. Oh, I smell marijuana. Sounds like you need a warrant, homeboy. Oh, the dog alerted me. Yet you find out the dog is wrong 35 to 45% of every encounter, and more wrong on alerts. So here's the thing. What you have to understand is everything that I'm giving you is not just for time to fill up or give you an opportunity to listen to my joyous voice, but it's also an opportunity to think. Understand it really is that simple. Because when I talk about the police encounters, I actually had some dumb woman tell me, well, you should give both sides. My problem is I don't need to give you both sides. Because that's not what I'm talking about. Because just like I'm doing defense, that's what I'm talking about. I'm talking about the initial start of defense, which begins with a police officer interaction. That's what I'm talking about. I don't need to give any other sides. Because here's my greatest part. Because I wasn't involved in the decision-making process of becoming a police officer. Yet I was involved in the process of being a human being, being part of the public. I am a willful participation of public peopleship. Why? Because I am a human being first. I'm going to give you another Jay-Z line. Because I did my studies and I downgraded to a human being. I am a human first. If you're looking to quantify who I am by my race, you can take your racist ass on. Because my skin tone or my geographical location should not determine if you treat me as a human being or not. It shouldn't determine if you're going to follow proper procedure or not. It shouldn't even determine your choice of police tactics if you're doing it lawfully.